like Chicago? I love Chicago.
You hear me? Okay, now it's on. Okay,
I've
I'm gonna
been
leave
there
it on.
It's probably been about
here in my office.
It comes. All right, here we go. Welcome to today's Code Board. Thank you for coming to today's Code Enforcement Board meeting. This board is empowered to hear evidence, to reach findings of fact, and conclusion of law for the purposes of resolving cases that come before it. A finding of violation may lead to the assessment of daily fines in the form of property liens. The board is always interested in statements that will help us make the determination in each case, and we are interested in compliance rather than levying fines. We will hear all cases in the order that they appear on the agenda, beginning with new violations, fine assessment cases, and status updates, and concluding with cases for which persons are seeking fine reductions. We can begin by having all the people who will be speaking before the board sworn in.
Okay, by the authority invested in me as a notary of the state of Florida, do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? You may be seated.
Awesome. First case. Oh, great.
You want to do the roll call?
Oh, gotcha. It's been 6 weeks. Can we call the roll, please?
Sure. Wayne Pasek.
Here.
Steve Butera.
Present.
Jimmy Canton.
Here.
Robert Cohen.
Here.
Richard Burgess.
Here.
Todd LaRue.
Here.
And Jennifer Jones.
Here.
Awesome. Can we make a motion to approve the minutes?
There are no minutes.
Oh, there you go.
And the changes to the agenda are as follows. Postponed cases are as follows. 25000025, 25000036, 25000033, 25000039. Compliance or closed cases are as follows. 253741, 253804, 253855, 254076, 254125, 255140, 25000001, 25000004, 25000007, 25000012, 25000017, 25000018, 25000019, 25000021, 25000025, 25000026, 25000037, and 25000040.
Awesome.
First case, case 1, 253857. The property owner is Laura Pepe Joseph, 47 Northwest 11th Avenue, and it's presented by Code Officer Delinda Wachowski.
Good afternoon, Board. My name is Delinda Witkowski. I am a code officer for Clean and Safe with the City of Delray Beach. I'm here regarding a dead tree violation located at 47 Northwest 11th Avenue. On April 19th of 2025, I inspected the property where I observed a dead tree that required to be removed, which is in violation of Code Section 4.6.19, subsection J, subsection 2, subsection A and B, which states that all trees and palm trees which are dead must be removed prior to hurricane season. Tree removal permits are also required. A landscape violation was issued on April 19th of 2025. The violation was mailed first class and certified on April 24th of 2025, and the compliance date was due for May 20th of 2025. On May 30th, I re-inspected the property, and the violation still existed. Due to not full compliance, a notice of violation was issued via first class and certified on July 10th of 2025. The certified mail was not received. The first class mail was not returned. Posted at the property and at City Hall on July 10th of 2025. I did knock on the property at the door. They answered, but they were tenants and they did not feel comfortable signing the posting, so I did post it and I did take a picture. The re-inspection was then conducted on August 9th of 2025. The violation still continued to exist. No permit was pulled. The tree was cut down, so they were partially in compliance, but they did not pull a permit, which was required Not only it was stated in the ordinance itself, but also in the narrative that I wrote that a permit was required. I have 4 photographs that I would like to introduce into evidence of this property. I have had contact with just the tenants, not the property owner.
Thank you. At this time, I'm now showing you what's been previously marked as City Exhibit 1 for identification purposes. Do you recognize this?
I do.
And what is it?
So that is the palm tree that is dead.
And when was this photograph taken?
This was taken on April 19th of 2025.
And just to be clear, it's the brown yes,
Yes.
tree-looking item
Yes, it is.
in the center of the photograph.
Correct.
City's Exhibit 2 for identification purposes.
So this was the reinspection photo on the first part, which was taken on April 30th. As you can see, the tree was removed. However, permits were not pulled.
So, okay, so completely removed or partially?
No, it was completely removed.
All right, and that was on May 30th, you said?
Correct.
Thank you. City's Exhibit 3 for identification purposes.
So this is just our reinspection photo that we have to do prior to coming to Code Board, which was taken on August 9th of 2025, showing that, again, the tree was removed. However, nothing was pulled in our system.
And did you, as a part of your duties and responsibilities, take a look at the city's systems to confirm that no tree permit had been applied for?
I did. In fact, I have it printed here showing that the last last permit that this address pulled was in 1999.
All right. At this time, the city would like to introduce the 3 exhibits into evidence.
I make a motion that we accept the photographs presented by the city 1 through 4 into evidence.
All in favor?
Second.
No, second. All in favor?
Aye.
Opposed?
Did you want to introduce the permit screen as well that you printed?
As exhibit?
Yeah,
Sure.
thank you.
So that would be exhibit 5.
Your Honor, I'd like to accept City's Exhibit 4 into evidence.
Second.
All in favor?
Actually, correction, that would be exhibit 5.
Well,
Okay.
it's more. We only have 3 photographs. Yeah, no problem.
I am sorry.
This time let's publish it to the board. Pass it down. I'm not sure if there's a homeowner present for this today. We can call the galley, please.
Is anybody here for this case?
If the board doesn't have any more questions for Ms. Wachowski, what's your recommendation?
So the city recommends that we give them 30 days to apply and obtain a permit, or $50 per day thereafter for noncompliance.
Linda, you said you still have to talk to these people.
Only the tenants. I do not know where the owners, they don't live there.
Questions? Make a motion.
Hey, Mr. Chairman, I would like to make a motion. Respect to case number 25-3857. I move for finding of fact and conclusion of law that there is good notice and that the violation of the tree removal without a permit exists based on the evidence and the testimony of the officer, and that the permit is not pulled, still exists. The offending party shall correct the violation of obtaining a permit within 30 days or pay a fine of $50 per day for each day thereafter for noncompliance. The respondent shall immediately notify the code enforcement officer when the property is brought into compliance. If the violation is not brought into compliance, the code enforcement officer shall report back to the board, and in the event of non-compliance, a lien for the daily amount shall be imposed on the property.
Second.
All in favor?
Aye.
Opposed? Motion passes.
Thank you.
Case number 2, 253933. The property owner is Evanilda Pessoa. Property address is 245 Southwest 11th Avenue, and it's presented by Code Officer Jude LeCount.
Good afternoon. My name is Code Enforcement Officer Jude V. LeCount II. I am here regarding a non-permitted fence installation located at 245 Southwest 11th Ave. On April 22nd, 2025, I inspected the property where I observed the property owner removing the chain link fence and replacing it with a wooden fence without a permit. which is in violation of Code Section 2.413B, which states, building permits is required for all items as set forth in the current Florida Building Code and Chapter 7 of these land development regulations as amended. A building permit shall be sought via application through the Development Services Department. A general notice of violation was issued on April 22nd, 2025. The violation was mailed first class and certified mail on April 24th, 2025. The compliance date was required by May 22nd, 2025. On May 23rd, 2025, I re-inspected the property. Notice of formal hearing was issued on June 4th, 2025. Regular mail and confirmation of receipt was not received. Posted at the property in City Hall on June 25th, 2025. Last reinspection was conducted on July 2nd, 2025, and as of today, there has been no changes. And I have had contact with the property owner, and the current permit status of today, the comments said that the property owner needed to show where the fence needed to be placed, and they have not made any adjustments. The city suggests obtain an approved permit for the new fence installed on the property in 30 days or a $100 daily fine for non-compliance.
Thank you. I'm now showing you it's been previously marked as City's Exhibit 1 for identification purposes. Do you recognize this?
Yes, this photo was taken on April 22nd, 2025. It shows that the new fence has been installed, and as of this day, there were no current permits on file.
And that is kind of like the tan fence in the
Yes, that's
center
the
of the
wooden
property?
fence.
Wooden, okay, thank you. City's Exhibit 2 for identification purposes?
This is taken on April 22nd, 2025, and it just shows another angle of the fence, and it shows how it's right on the sidewalk.
City's Exhibit 3 for identification purposes?
This is a picture taken of the mailbox just to identify that I am at property 245 Southwest 11th Ave, and you can also see the old chain link fence, and you can see the wooden fence has been installed.
So the chain link fence to the left of the red vehicle, that's on the same property?
Yes, it was
Okay.
originally around the whole entire property, and then one day they just removed it and started installing the wooden fence.
Okay, thank you. City's Exhibit 4 for identification purposes?
This was taken on May 23rd, and it just shows from a wider angle, it shows that the fence is still there, and also there's no permit on file as of that day.
City's Exhibit 5 for identification purposes?
This is a picture that was taken on May 23rd, 2025, and it shows a complete view of the property, and you can also still see the chain link fence at the front of the property in the distance of the photo.
All right, City's Exhibit, okay. At this time, the city would like to introduce the 5 exhibits into evidence.
This case was also given a 30-day continuance from before to give the property owner time to make the adjustments. But on July 10th was the last time that Inspector Story spoke with them and left comments, and no comments were adjusted. So that is why we're here today.
Okay, if we can get a motion to accept the exhibits into evidence.
Mr.
Mr. Chairman, I move that we admit the documents in exhibits 1 through 5, photographs as shown, submitted by the city.
Second.
All in favor?
Aye.
All opposed? Pictures are in.
Mr. Chairman,
Yes, sir.
I was trying to listen to the testimony. Is this a replacement fence or a permit issue?
It's a,
Exactly, is it the problem with how it's installed, or just the violation is
permit.
just the permit?
Correct?
Yes,
Yeah,
it's the
just the
permitting, and also, as I say, when you install a fence, there are certain setbacks and regulations that you have to follow. And just by viewing the picture, it's right on the sidewalk, so I can visibly observe that they're already in the wrong.
So, Mr. Chairman, am I understanding, sorry, Bob,
Tora, I want to ask a question.
I want to understand that he's saying there could be violations, but because he didn't get a permit, they're not there, so.
Violation for us is a permit.
Got
A
it.
lack of a permit.
Thank you.
No problem.
We don't have a map, a pop map or anything at this point, but my question is, is the new wooden fence on the property line or someplace other than on the property?
so can I just gear us back to the specific violation that we're here for? Right now, you
mentioned
have
the fact that
to,
they need setbacks, and that's exactly what I'm questioning.
right, but we haven't even gotten there yet, because the process is, what we're here for is a fence, installing a fence, period, without any type of permit.
That's why I asked the question.
Right.
It's just the permit.
Yes.
Yes.
We're not trying to figure out where it should be.
Exactly. Once they apply, we'll figure out the setbacks and all of that and whether it's even allowable. But we can't get there without the actual permit approval.
Jim?
Has there been contact with the owner?
Yes, on various occasions. They even came to Code Board last time where the extension was presented to give them opportunity because they're close to completion, but they didn't make any adjustments, and that's why I made note that Thomas Story did put in our program system that they needed to identify exactly where the fence is gonna be on the property. So they haven't corrected it.
All right, thank you.
And they need to do that to get the permit for the fence?
Yes, which will make it approved.
When was the 30 days given?
The original 30 days was given last Code Board.
And the compliance date was May 22nd.
Yes.
Thank you.
Awesome. Any other questions? They're not here. Anybody here for this case?
I got one question. So
Yes,
did
sir.
we give him a violation last time, or we just gave him the opportunity to fix it, and now he's right back?
No, they originally had a violation, but when they came to Code Board, because they were right at the door to finish, they were given, as I said, a courtesy extension or a continuance by the board to allow them to do that, but they didn't come in and correct those steps. So now we're back here again.
That being said, what's your recommendation?
The city should just 30 days to get the permit approved, because I'm not exactly sure what other details would be required, but after that, $100 daily fine for non-compliance.
This case number 6933.
Mr. Chairman, I would like to make a motion with respect to case 253933. I move for a finding of fact and a conclusion of law that there is good notice and that the violations of the installation of a replacement fence without
you.
a permit exists on the property. The offending party shall correct all violations within 30 days by obtaining a permit or pay a fine of up to $100 per day for each day thereafter for non-compliance. The respondent shall immediately notify the code enforcement officer when the property is brought into compliance. If the violation is not brought into compliance, the code enforcement officer shall report back to the board, and in the event of non-compliance, a lien for the daily amount shall be imposed on the property.
Mr. Chairman, I second.
All in favor?
Aye.
All opposed? Motion passes.
I have a question before we proceed with, not for you, sir, for Mr. Wagner. Is statute like 30 days to comply, or can there be any set time? And also the amount of a fine?
Yeah, so Chapter 162 dictates that you give a reasonable amount of time to comply. So 30 days is not mandatory. You can decide. It's actually the board's judgment about what is reasonable. The fine amounts are typically up to a certain amount. Based upon the size of the city in Chapter 162, I believe in Delray, what's the limit?
$1,000 up to for fines.
So, but again, it's the amount is discretionary to you. What the city recommends to you is what they think is appropriate.
Because in my thought process, and I don't mean to speak out of line, my thing is that the average person that has an issue with a fence, they may not know they need permits or interior work, they may not know it. But the thing is, just if you have to go and get an architect or do a survey or, apply for permits, a 30-day window, it seems like we see the same cases over and over and over and over, where if it was like a 60-day window and say a $200 a day minimum fine, it would incentivize the people to, hey, I got to get this done in 2 months. At least that allows me to budget for it or prepare for it.
The short answer to your question is that that's really up to the board, right? It's the board that decides what they think a reasonable amount of time, given the facts as you understand them. And remember, the facts in any case, right? Because we're talking about the standard. There's no real standard. There's just what you think is appropriate. What is, I guess, let me rephrase that. What you think is a reasonable amount of time for them to come into compliance, given the facts as you understand them. And that is up to you. And so in a case you may agree or disagree with the city's assessment. You may also inquire to the city as to how they reached their conclusion and some of the facts that you think are important that might make you reach a different conclusion. That's all well within your discretion.
I just, for personal experience, I just went through a permitting process in another municipality, and it literally took me 8 months from cradle to grave to get permits and inspections done for a 2-day repair.
Yeah, I mean, the what is reasonable may not be apparent, right, on the face of the facts as you understand them. So it is perfectly okay for members of this board to inquire, if you're asking them to comply by this date, can you tell me whether that's reasonable given the city's processes, right? You can ask a question like that. It's perfectly okay to do that.
But remember, in this case, for example,
Okay,
just as an example,
this case is
not
concluded.
talking, not talking about
yeah.
details of it, but
Yeah.
this case or any case that we typically see has started typically months before it comes to us, and the code enforcement officer has usually made multiple attempts to contact them, let them know what needs to be done, take steps, and so by the time it gets here, they should know what they need to be doing, and they should have been started on doing it. And
Yeah, with that said, it is because sometimes it feels like if a case took a while, a hypothetical case, if it took a while, then it's okay to be short on the time frame. But still remember, the requirement under Chapter 162 is that you give them a reasonable amount of time to come to compliance. What that means in plain English is that you cannot set a compliance date that is impossible for them to comply with. You have to give them a reasonable amount of time.
Okay, so I have a question on that. So should we have a discussion on that before we make the motions?
Well, we've already.
It's already the case is.
We're not talking about any case. We're just talking about
in
stuff
general.
in theory. It is always reasonable. There are a couple of places where it is reasonable for this board to inquire as to compliance time reasonability. When you are examining the witnesses, you can ask questions about, well, if compliance means X, what is it typical for someone to accomplish that within the time frame of the city? That's always reasonable. When somebody makes a motion with a time frame in it, which is typically most of our motions, right? When somebody seconds it for discussion, you can also have a discussion or make inquiry as to whether or not you think the motion itself is giving a reasonable amount of time. So you can make those inquiries in multiple times. And then, by the way, that is part of the judgment that you're supposed to bring here, which is what is reasonable.
Yeah, one little side note is that watching other meetings and reading on the social media forums, it's like, code enforcement isn't doing enough, which being on this board and seeing what staff does here, they do above and beyond. So I take that as an insult, and it bothers me. So it's just like, we don't see code anywhere. Well, they're out working. And as soon as someone has a problem in their neighborhood, they want like immediate attention. So it's just, if there's not so much time like bottlenecking and just chasing these cases and giving people more time and then being able to go out and enforce more, just try to make everyone's life easier.
Yeah, and I think because we spent a little bit of time talking about your job and judging what is reasonable, and that is part of your job, but of course your job is also to try and encourage compliance, right, with the code. So you have to weigh, what it is, as we say, the stick and the carrot in trying to get compliance, because ultimately that's the goal, is to get compliance, right?
Interesting. Thank you.
I think we're ready for the next one.
Yep.
Okay, case number 3, 253953. The property owner is Martin Saramar LLC. Registered agent is Henry Dean. Property address is 122 Southwest 12th Avenue, and it's presented by Code Officer Jude LeCount.
Good afternoon. My name is Code Enforcement Officer Jude V. LeCount II. I am here regarding a non-permitted iron fence install located at 122 Southwest 12th Ave. It was done on April 25th, 2025, where I inspected the property and I observed a new iron fence being installed around the front of the property, which is in violation of Code Section 2413B, which states, a building permit is required for all items as set forth in the current Florida Building Code and Chapter 7 of the Land Development Regulations as amended. A building permit shall be sought via application through Development Services Department. A general notice of violation was issued on April 25th, 2025. The violation was mailed first class and certified mail April 28th, 2025. The compliance date was required by May 25th, 2025. On May 28, 2025, I re-inspected the property. Notice of formal hearing was issued via first class and certified mail on June 4th, 2025. A certified confirmation of receipt was received on May 14th, 2025. Posted the property in City Hall on June 25th, 2025. A re-inspection prior to hearing was conducted on July 2nd, 2025. As the last re-inspection, the violation still exists. I have photos taken of the property in question. I have had contact with the property owner.
Okay, thank you. I'm now showing you it's been previously marked as City's Exhibit 1 for identification purposes. Do you recognize this?
Yes, this photo was taken on April 23rd, 2025, and I observed the preparation and start to install the iron fence.
Okay, is that the kind of the post, the iron post?
Yes, and that's also the truck, the work truck.
All right, City's Exhibit 2 for identification purposes.
April 23rd, this also shows the work truck and the equipment, and the material that is going to be used to install the fence.
All right, that was again on April 23rd, right?
Yes.
City's Exhibit 3 for identification purposes.
This is a picture that was taken on April 23rd, 2025 that shows the start of the installation of the iron fence right against the sidewalk.
All right, City's Exhibit 4 for identification purposes.
This was taken on May 28th, 2025, and this shows that the fence has been completely installed since the last inspection and no permit is on file.
And just to be clear, notice was provided on prior to the completion of the fence, correct?
Yes.
All right, and
Violation was issued in May.
all right, thank you. That's Exhibit 4. Again, this is on May 28th.
Yes.
All right, is this, you said it was completed?
Yes.
All right, City's Exhibit 5 for identification purposes.
This just shows another angle and it shows another portion that has been installed for the iron fence on the gate.
At this time, the city would like to introduce the 5 exhibits into evidence.
This was also a case that was given a continuance for corrections, and today, me and the property owner, we met with Mr. Story, and he informed him of the exact details that needed to be corrected, which was not the property owner's fault. It was the contractor who he hired did not communicate in a timely manner as he was supposed to. So the property owner has been doing what they're supposed to, but the reason he hasn't crossed over now is because that his contractor did not follow up with Mr. Thomas and complete the details that were given.
So, based on this, did we introduce the 5 exhibits, correct?
No, we have not.
Okay, can we introduce the 5 exhibits into evidence, please?
Mr. Chairman, I'd like to introduce City's Exhibits 1 through 5 into evidence.
Second.
All in favor?
Aye.
Opposed? Picture.
And I believe the homeowner is here, but just before we even get there, what is your recommendation considering this new conversation that you've had with the homeowner?
To give him 30 days to have it approved because he's completely aware now of the comments that need to be corrected by his contractor that's installing the fence, or a $100 daily fine for the non-compliance.
No further testimony from the city.
I have a question on that testimony.
Yes, sir.
Is the city stating its position that it should be feasible to obtain the permit within 30 days?
Yes, because
Thank you.
through the conversation we had today, and everybody, all parties agreed that it's obtainable to complete and make those adjustments to the fence.
Thank you.
No problem.
Sir, is there something you'd like to say?
Yes, please. First, I'd like apologize because English is not my first language.
What is your first language, sir?
Portuguese. But can I try, and if not understand?
Well, I just want to be have you understood everything that's happened here
Yes,
today?
yes.
So you have understood?
Yes.
Okay.
Do we need to swear him in? And
I believe,
his
were you
contact.
sworn in?
Excuse me?
Did you get sworn in
Yes,
earlier?
yes, before.
I just wanted to be clear because he said about English is his second language, that he fully understood everything that's happened.
We also provided him a physical printout. Mr. Story provided him, and we showed exactly.
Yeah, I would like to say thank you for Mr. Judge and another guy because he tried to understand me more and try to explain more than another people for the city.
Okay.
But I have some questions because I have a situation. It's 2 different houses, it's 2 different permits, and the city allowed. I don't wanna make sure nothing wrong in the future. I have a problem with another inspector press the home and make me give me hard time because the city allowed for the permit for the house 126 and not allowed for 122. Asking about the permit for to put the fence back. And the first time I tried to resolve this with the city, but the lady attended me, she not was so explained very well, I think. And she not, because she told me, I take care about the house 122, I'm not make for 126. But today I realize with the city have some mistake for the city, I think.
Okay, so now do you understand everything that you have to do?
Yes, because why if the same house, both sides is the same, the department for the enforcement asked me to put it 20 feet back. If the 126, the city allowed to stay on the same places now.
Okay, so that's something that the building department that we're working
What he's
out.
speaking about is in his plans for the gate, there's a sliding closing gate.
Right.
So basically what he's speaking about is at one of his properties, the part that he has to correct at 122 was approved at 126. And the planner was letting him know that, hey, there was two different set of eyes that viewed two different plans with
Okay.
two different
So-
parcel numbers and properties.
so-
So that's what he's saying,
so-
he was confused.
So again, considering all of this, is this something that's feasible to
Yes,
get
in
done
30
within the
days.
30 days? And I don't believe we got your name and address, sir, for the record.
My name?
Yeah,
is
and address.
Marcus Martins, 159 Andover Street, Low Mass, Massachusetts.
Okay, thank you.
I have one more question, more concern, because I tried to resolve this long time ago. I went to the city, talked with the department, with the build department. They told me, do not show nothing. I think have a miscommunication for both departments, because I don't know the date exactly. They told me it's okay. I still receiving a letter in Massachusetts. Last month I take fly, coming here to resolve. The board and give me more 30 days to resolve that. And also I think I not found a good company to do the fence, because they don't just tell me, oh, I have some issues with the city hall. They not exactly tell me exactly what's going on. And today I realize something is wrong, because I still do not understand why the city allowed to do the fence
Okay.
126, not 128. 122, sorry.
Oh, no, that's okay. It's the board chair.
No,
I
I
don't have
wanna
any
hear-
questions.
hear
I don't have
everything.
any more questions for him.
Okay. Anybody want to make a motion?
I have a question.
Yes,
for
ma'am.
him. Do you feel that 30 days is enough time for you to get this done? You just mentioned that you had a 30 days extension already and you were traveling.
I will try with the city if they try to not help me, but treat me looks like I'm paying for the bills, for the tax for the city, because me and my wife choose this house. We choose for this house 5 years ago, the best city to invest in in Florida, and also in the future live here if we got permission. If I think it'll be enough.
Okay.
I have a question.
Yes, sir.
Was I to understand that he attempted to apply for a permit before putting the fence in, yes or no?
The permit for 126, okay, basically the property is only showing the property that's in question.
On this property, on this case?
Yes, but the property is a duplex, so he applied for all the permits except just for the fence for the 122. But he's applied for all other permits, so that was just the misunderstanding of the missing piece.
So he
Thank you
didn't
for-
apply for
thank
He
you.
122.
didn't, yes,
Thank
he
you.
didn't apply.
I needed to understand. Thank you.
Oh, okay, no problem.
So is there a permit for 126 and not for 122?
Yeah, now it's a permit for 122, it just hasn't been approved due to the comments that have to be fixed, that he was made clear today. And we
I
printed
think
out.
she was asking for 126, not 122.
Yeah, 126 is fine, it's no violation.
So, right, so, okay, thanks.
Motion, Jim.
Mr. Chairman, I would like to make a motion with respect to case number 25003953. I move for finding of fact and conclusion of law that there is good notice of violation, that the permit was not properly applied for. Violations exist on this property. The offending party shall correct all violations within 30 days or pay a fine. What was the city's recommendation?
$100 daily fine.
Of $100 per day for each day thereafter for non-compliance. The respondent shall immediately notify the code enforcement officer when the property is brought back into compliance. If the violation is not brought into compliance, The code enforcement officer shall report back to the board, and in the event of non-compliance, a lien for the daily amount shall be imposed on the property.
Second.
Second.
All in favor?
Aye.
Opposed? Motion passes. Thank you, sir.
Thank you, gentlemen.
Sir?
Case number 4, code 25000003. Property owner is Patrick Bolin, and the property address is 512 Cortez Lane, presented by Code Officer Chantel Jean Baptiste.
Good afternoon. My name is Code Enforcement Chantel Jean Baptiste. I am here regarding a landscape violation. On June 9th, 2025, I inspected property located at 512 Cortez Lane. On June 9th, 2025, I inspected a property where I observed vehicles parked on the landscape, which is in violation of Code Section 4.6.16, subsection E, subsection 3, which states no vehicle encroachment over or on any required landscape area. A landscape violation was issued on June 18th, 2025. The violation was mailed first class and certified on June 18th, 2025. The compliance date was required by June 24th, 2025. On June 25th, I re-inspected property. Subsequently, a notice of formal hearing was issued via first class and certified on mail on June 25th, 2025. Regular mail was not received. Posted at Property and City Hall on June 25th, 2025. A re-inspection prior to hearing was conducted on June 25th, 2025. As of my last re-inspection was on August the 12th, 2025. The violation still exists. I have 5 photos taken of property in question, and I have made contact with property owner on June 12th, 2025.
Thank you. I'm now showing you has been previously marked as City's Exhibit 1 for identification purposes. What does this photograph depict?
The photograph shows 2 vehicles parked on a landscape and also on the Jeep. You can see the landscape is already dying for the long period of the vehicle being parked on here.
And that was on June 9th?
Correct, June 9th, 2025.
City's Exhibit 2?
So my re-inspection was taken on June 25th, 2025, and the vehicle is still on the landscape.
City's Exhibit 3?
On June 25th, I also posted on property.
Thank you. City's Exhibit 4?
This was my last re-inspection taken on August 12th, 2025, and I also spoke with the property owner on this date.
City's Exhibit 5?
Same photos, no compliance, August 12th, 2025.
Thank you. And as a part of your duties as a code enforcement officer, do you oftentimes drive down this area and view the property?
Yes.
And this has consistently been this way, correct?
Correct.
All right. At this time, the city would like to introduce the 5 exhibits into evidence.
I move that we admit the pictures submitted by the city into evidence, Exhibit 1 to 5.
Second.
All in favor?
Aye.
Opposed? Picks are in.
Does the city have a recommendation?
City recommends 7 days to remove all vehicles off the landscape or $50 daily fine.
When you talk to the resident, what they say?
On August 12th, what he said, he will remove the gold one immediately, but he's gonna need time for the white Jeep, and I asked, why is that? And he was like, oh, there's a piece that needs to be repaired, I don't know, to be fixed in order to move it.
So the
that's
vehicle's
issue.
also
I didn't know
inoperable.
I didn't know it was inoperable because the tires were inflated, but when he told me that, that's when I learned that the white one is inoperable.
Thank you.
Questions?
Yeah, did the owner fully understand the extent of the...
He understands. He understands.
And what was the reason other than the part? Is that the only reason why they have not been compliant in
The
the
gold
past
one,
2
he
months
said
that
he
you've
would
tried?
move immediately. He said the only reason the white one won't be moved immediately is because there's a piece that's missing that needs to be fixed in order to move the vehicle.
And that was as of the 12th.
Correct.
And the 7-day to comply will be effective today, 7
Today,
days? Or from?
correct.
Thank you.
Questions?
Can we ask if there's anyone present here for this case, just if you wouldn't mind calling out?
I didn't understand what the city's recommendation was.
First of all, is there anybody here for this case? No. 7 days and
7 days to remove
$50
the vehicle
per
off
day
their landscape.
to move those cars.
I'm puzzled, and I don't like the way this keeps on going. The car is inoperable. Tell him he has to tow it. Don't leave it because he's waiting for a part. Because he's going to say, well, this part, I can't find anybody to sell me this part. I'm going to wait and wait and wait. Maybe I'm going to find a part to repair the car. No. Have it towed to a service station where they can have it and fix it, or tow it someplace to a storage yard. I'm unhappy giving them an excuse to not remove the vehicle because it's inconvenient for him.
So I would just want
understand
to
when
wait a second, Chantel. Let me answer the question here. I just want to redirect us back to what we're here for. The violation. The violation is parking on the grass. The only reason why this even came up as to what the rationale was, we're not giving them an excuse, right? Our goal is compliance, however they want to do it, whether it's towing, whether it's moving, whether it's fixing. Our goal is to just get, have them remove the vehicle. So, I would just like to put out there, it's not like we're giving them an excuse. She was just simply asked what the property owner told her.
I understand, but my opinion is that he's not going to move it for quite a while, and he's going to rely on making excuses to the inspector why he can't move it. And that's just, to me, they're just laughing at us. They're just saying, I'm sorry, it's inconvenient for you to move this car. That, to me, is not, he's known about this for how many months? How many months could he have spent to get the automobile fixed so it works, or tow it away if he doesn't want it? But I'm just unhappy just giving him more and more leeway.
Well, all the city's proposing is that we give him 7 days of leeway
I
and
understand,
then
but she's saying
begin fining.
we can't make a suggestion to him.
We can't make a suggestion how he can fix things, but we can certainly tell him,
I'm
here's the
just
deadline to get
I'm
it
just
fixed.
feeling it. I think we're just being,
I have a
fooled
question, Mr. Chairman.
by not being able to help out.
Jimmy, may I?
Sure.
Thank you. Mr. Chairman, with reflect to the advice of our counsel in a hypothetical situation based on the other board members' concern of reasonableness, I think that I can deduct by looking at the photographic evidence and listening to the testimony of the officer that it's very plausible and possible for the respondent to correct us within 7 days. I think it would be really easy to do.
Yeah.
I don't see the challenge with what the city's asked for.
I could correct it in 5 minutes. Move the gold car, push the white car on the
you.
driveway, and you're done.
But in fairness, we want to
It's
consider.
just common sense.
But that was my question. If the homeowner
I'm
moves
fat.
the
I
vehicle
can do it.
into the parking, the driveway, is that gonna be a potential another violation? Or would that actually bring him into compliance?
I don't think
Okay,
that's-
just so I can keep us on track. In any given case, it's quite possible, because you become familiar with the codes the longer you do this, right? That you may see something that you think might warrant a code violation. But it is not the job of this board, and it is certainly beyond the scope of this board's authority to cite for any new violations. So I know sometimes we have a tendency to do it. God, heaven knows I sometimes want to do it. But you have to just stick with what the city has cited them for. If there is another violation that may or may not be in existence or may come into an existence, that is up for the city to cite it and then bring it back to this board.
And how much daily fine did you recommend?
50.
50 a day.
I'll make a motion. Mr. Chairman, I'd like to make a motion with respect to case number 25-00003. I move for a finding of the facts and conclusion of law that there's good notice and violation with regards to his vehicle parked on the existing property. The offending party shall have 7 days to correct the violation, and I would suggest a fine up to $200 per day for each day therefore after non-compliance. The respondent shall immediately notify the code enforcement officer when the property is brought into compliance. If a violation is not brought into compliance, the code enforcement officer shall report back to the board, and in event of non-compliance, a lien for the daily amount shall be imposed on the property.
Second.
Anybody want to discuss this?
I do.
Yeah.
I agree with the daily fine. I think $200 might be stiff. Can we compromise?
See how quick they move the car at $200 a day. There's a compromise.
Yeah, well,
Time is money, and code enforcement is busy.
I agree. We also don't know what people's lives are like.
It's been seconded.
This is an easy fix.
And now we take a vote.
If there's no, I mean, you can determine if there's no more discussion, then you can call it.
I would just explain to people that don't think about it. 7 days, the inspector could go and re-inspect and determine after 7 days the violation hasn't been cleared. And at that point, we're saying we're going to put a lien on the property of $200 a day. But remember, I think, until the next board meeting, we can't impose a lien.
So I believe the question, we're asking for a $200 a day daily fine. If we wanted to proceed with the lien, we would bring it back in for a finding that the property is still out of compliance, and we would request authorization to lien at that point.
I understand that. I'm saying that's a month till we get the chance to consider.
But they still
that-
owe the
that's just-
fine.
that's just
It's
process.
just whether or not it's been actually liened on the property.
I agree. That's what I'm saying. It takes a whole nother month and another board meeting to find out and come up. And they'll probably, maybe if they're smart, they'll get it done in 14 days, and we'll only fine them for a few days rather than a whole month, because it took us a while to get around to deciding whether or not we need to lien.
I know the process can be cumbersome, which I guess is the point that Mr. Cohen is trying to make, and that is a fair point for him to make. Though structurally, the lien starts running the moment your order has been not complied with.
Day 8.
So hypothetically, if you said 7 days, on day 8 the lien would start running. The fine would start running. It's not a lien on the property until this board comes back and liens the property, but it's not, your initial order is operative.
Right.
Okay, that helps. Thank you.
We'll take a vote. We have a motion. All in favor?
Aye.
All opposed?
Aye.
Motion passes.
I'd just like to say, I feel this board's very sympathetic to structural issues sometimes, electrical, plumbing, permitting, but this is an easy fix.
Yes.
And this is really consuming code's time, where you just push it over 10 feet and it's done. Or get it towed. It's less than $200 to tow a car. And it's over.
This meeting feels a little bit like a workshop, which is good, I guess.
Just trying to help people.
Yeah,
push it
but
along.
I think in the abstract, and again, not referring to any particular case, in the abstract, it is perfectly reasonable for you to tailor the fine to what you assess as a reasonable incentive for them to come into compliance within a time that it's reasonable for them to do. The operative word here being reasonable, right? And that is exactly your determination. That's exactly your job, which is to make, to assess what's the gravity of the violation, how long should it take them to come into compliance, what is likely to produce compliance, and what is a reasonable amount of time for them to do it. All those things are things for you to weigh and conclude.
There's a big discussion in the city about revenue stream. I
Mr.
hear in
Chairman?
all the meetings.
Yes, sir.
Could I ask the attorney for reference, just to remind people on the board and new members, what the frame of the potential fine is from $0 to what dollars?
Yeah,
Per day.
it's set by statute under Chapter 162, which has to do with the size of the city because of Delray's size and what's been adopted by ordinance. This board is authorized to fine from as little as $1 or no dollars, actually. I guess you could zero fine it if you wanted to, up to $1,000 per day. If it's a repeat violation, my recollection, I believe, is that's up to $5,000 per day.
Yes, and then it's an irreparable, it's $15,000 for total for the fine.
Yeah. So structurally, it depends why they're bringing it. If it's happened before, and you're always authorized when you assess such things to assess the gravity of the violation, the actions taken by the respondent. These are the things that you weigh when you're assessing those fines.
Thank you.
Quick question, follow up on that, Mr. Wagner. So there's no limit on how many days, just the total fine is capped at 15,000.
No, it's actually there is no cap
Okay.
per se. There is a question in the
So this can go
I don't know how deep we
365
want to get
days,
into the
like
case
that.
law here.
Okay.
There is some question about whether or not a fine that's been running for a mighty long time might be unreasonable and constitutionally insecure, but that's a that's a
whole
distant
other
kind of
ballgame.
universe. But theoretically, the cap is a daily cap. It's not
Okay.
a
It's per day,
longevity
not
cap.
many days. Until compliance.
And I would just point out to somebody new, we see some cases in here where the amount of time that the fine has been ignored is sometimes
These things
unbelievable.
these things can definitely, and this, I mean, we talked about structurally how you assess the fine, but of course this board, also today might actually do it, is also empowered to reduce fines where appropriate as well. And so this board can come back should the person petition, and then you can weigh things again, like their actions, the gravity, and make a conclusion about what is appropriate. But yeah,
You may see if you stay.
see, we're workshopping.
The thousands of dollars that these liens get to is absolutely amazing. That people
Okay,
ignore
case
this.
number 5, code 25000033 was postponed prior to this hearing today.
Actually, we need a motion from the board to postpone the cases. So my understanding is that they've been working with staff, so we're just asking the board for to postpone the case to the next available code enforcement hearing.
Chairman.
Mr. Chairman, I'd like to make did I interrupt you again? Your turn.
Mr. Chairman, I'd like to make a motion to case number 2500033 to postpone this case to further notice.
Second.
Before we
asked-
second, do we want further notice or to the next available code enforcement meeting as the city requested?
What is your recommendation?
The next available code enforcement hearing.
Amend that motion to the next available
Code date.
code date. I'm sorry.
Second.
All in favor?
Aye.
All right.
All opposed?
Okay, case number 6, code 25000038. Property owner is Michael and Lisa Lichko. Property address is 45 Northwest 8th Avenue, and it's presented by Code Officer Delinda Wachowski.
Back to the tree.
Good afternoon, Code Board members. My name is Linda Witkowski. I am a Code Enforcement Officer for Clean and Safe with the City of Delray Beach. I'm here regarding a tree pruning violation located at 45 Northwest 8th Avenue. On March 26th of 2024, I inspected a property where I had observed 2 severely hat-racked trees, which is in code violation of 4.6.19, subsection F, subsection 1 to 2, which states that the purpose of pruning of trees is to allow for uniform and healthy growth. Pruning of tree limbs on a regular scheduled basis will improve tree health. However, severely cutting back branches and canopy or hat racking is expressly forbidden. A landscape violation was issued on July 2nd of 2025. A violation was mailed first class and certified on July 7th of 2025, and the compliance date was for July 23rd of 2025. A certified confirmation was not received. Irregular mail was not returned. Posted at the property and at City Hall on July 3rd of 2025. It was posted because no one was home at the time. A reinspection prior to a hearing was conducted on August 13th of 2025, which was yesterday. And I have 5 photographs that were taken of the property that I would like to introduce to you guys as evidence.
Thank you. At this time, I'm now showing you it's been previously marked as City's Exhibit 1 for identification purposes. What is this exhibit?
This is actually from property appraisal. It's just an aerial vision of the property that was taken on January, I believe, of 2024.
Okay, so let me just ask you a couple background questions. As a part of your training and experience, do you typically look at the property appraiser website to identify the nature of a property before a certain date?
If it's relative to the case, yes.
Yes, but that's a part of your training
Yes.
experience, correct? And in this particular case, was it your area that you patrolled to identify the particular trees in question?
Yes, it was.
And once you identify those particular trees in question, do you believe that they had been hat-racked, correct?
I actually, on this case, I had been called there from my bosses at the time, and they called me to take this case on.
Right, but when you went there and you saw it, it looked like the trees had been hat racked, correct?
Absolutely.
All right. So as a part of your training experience, did you try to identify what the trees looked like before you went there?
Well, it's an area that we drive by practically every day. So, at one time they were good. The next day they were not.
Right, but typically you try to see if you can figure out what the trees look like before you saw them hat racked, correct? And in this particular case, did you identify the property appraiser's website, which is a public record, correct, as a way to identify what the trees look like before?
Yes.
And thank you. And this particular screen, the way these work is they identify a period of time for the photographs. And I believe in this case, it's December 23rd through January 24, correct?
Correct.
All right, thank you. Cities Exhibit 2 for identification purposes. What is this? When was it taken?
Okay, so this is actually where, when I was called out to the location, which was on March 26th of 2024, where it's the tree that's on the south side of the building, of the structure. So there's two different trees. So that is one on the south side.
Okay, all right, Cities Exhibit 3 for identification purposes.
And this tree is actually on the northwest corner of the house, which was taken on March 26th of 2024.
Thank you. And you can tell hack rack, which just means how the limbs have been excessively cut, for lack of better words.
Yeah, the branches and everything was just severely cut back.
Thank you. So I just want to go back to Cities Exhibit 2. Are these the two trees on the property?
Yes, they are.
Thank you. Cities Exhibit 1, I believe. Cities Exhibit 4.
So this is just our reinspection prior to hearing. That is, custom as what we're supposed to do, which was on August 13th of 2025 was yesterday. I took a better picture of the tree that's on the south side of the property.
Cities Exhibit 5.
The tree that's on the northwest corner of the house, taken also yesterday on August 13th of 2025.
And there has been a time difference because the city was attempting to try to work with the property owner?
It's been a process that's been going back and forth for quite some time.
Thank you. At this time, the city would like to introduce the 5 exhibits into evidence.
I have a question.
As far as the photographs go,
Oh, we can. I'll make a motion. I move that we admit the documents, the 5 photographs by the city, into evidence for case number 250038.
Second.
All in favor?
Aye.
Opposed? Thank you.
Question: when you say quite some time, how long or how's the interaction been with the owner?
So this was inspected and seen on March 26th of 2024.
So he's just not responding to your request.
well, go ahead.
Yeah, I'll let go ahead, Luana, the attorney.
So I wouldn't necessarily say that it's been a lack of response. I'll have the testifiers, which is the code officer and our senior landscaper, possibly answer that question. But to surmise or proffer their testimony, it's more so the city's been going back and forth, trying to work with the property owner, making sure we identify the rightful owners, etc. So that's when she says process.
So
You're welcome.
it's been a 16-month period. So I don't know much about trees, but were the trees sick? I mean, I know trees and bushes could get like a fungus or get sick. So did they have to be hat racked because they were not healthy trees, or did they do it because they wanted more sunshine, or were they laying over the house argumentatively? Like,
So what I'll do is we actually have our senior landscaping planner here. He can probably answer all of those questions about what hat racking is, any questions about the specific ordinance, but I'm not sure if we can testify to what the owner's intent was for doing what they did to the trees.
Mr. Chairman, prior to the testimony, I just want to be clear about what bringing it into compliance would be prior to listening to testimony. Thank you.
the tree got to grow.
So,
Prior to listening to testimony, I would like to know exactly what coming into compliance means, Ms. Warren. Thank you.
yes.
So actually, on this part, we are going to hand it over to our landscaper. Our senior landscaper is here to give him guidance as far as giving also the suggestion from the city.
So if you can please give the suggestion.
Yeah, so as far as hat racking, or when the tree is cut this severely or hat racking, it's pretty much damage without removal. So in the ordinance, that calls for a permit for removal. When you damage a tree to this severe on a single-family lot, you have to provide mitigation per DBH. DBH is diameter at breast height. It's basically 4.5 feet above the ground where we measure the largest circumference of that tree's trunk. On these tree trunk at those times was between, I believe, like 12 and 15. Minimum size tree for a single family home is 12 foot. Coming in from the field, that's probably around 2 inches. So technically it would probably take between, 6 to 7 trees to replace this one. And that's compliance. Yes, so to answer your question, this case has been going on for quite some time. It's been a difficult case. I personally haven't spoken to the owner, heard from the owner. My knowledge is he doesn't want to speak to me. He doesn't want to deal with me.
Well, it's specifically about the trees.
No, this is about the trees.
No, I mean, as far as, I think the question was.
Were they disease ridden? Were they just cut by mistake?
My knowledge is they did not want the trees. They were caught in the act, and this is the state that it understood.
So as far as the recommendation, is it correct that the city is seeking for 30 days to apply and obtain the proper permit needed, the landscaping permit in accordance with the code section, and follow any recommendations provided in accordance with the code of ordinance from you?
So, yes.
And I'm so sorry, what was your name and your position with the city?
My name is David Glover, and I'm the senior landscape planner.
Thank you.
But that's a current picture of the tree, is it not?
It is.
It is.
So the tree's growing back.
Okay, so let me ask you
So they
this.
want to get a permit to take the tree out that's growing back?
Okay, well, we didn't say removal, we said proper permit. So the permit, as Mr. Glover said, could be mitigation. So the mitigation could be replanting a certain amount of trees, trying to prune this tree to come back to life. So that's the answer to your question.
Can I expand on that? So, to build on Stephen's question, how many specific number of trees does the homeowner has to plant, or are you asking him to remove it? Like, what is the specific?
So I'm not trying to take the answer away, but this is a specific. The reason why I'm interjecting here is because it's a specific code question, right? We have a specific code section which gives individuals options on how to come into compliance with the mitigation, and that really depends on what they submit to the city as far as how they want to handle it, right? So there's different variations based on what the homeowner has to do. So correct me if I'm wrong, Mr. Glover.
So compliance here is apply for the permit.
Right, and consult with the senior landscaping to figure out which process or direction that they want to go in to mitigate
30
this
days
issue.
to apply for a permit, get it approved, and that means talking to you guys and figuring out what to do.
Correct.
Correct.
Exactly. During discussion, when we as homeowners, because we're all property owners or residents here, do something without a permit, we're kind of avoiding the city supervision and city codes.
Sure.
So you're quite simply asking that we make sure he applies for a permit, and that within whatever that permit is, he'll have to.
Yes, and I'm so sorry. I believe Mr. LaRue was saying something. I just want to make sure we get everything on the record. I couldn't hear what he was saying.
He was simply asking whether or not we had called for anyone in the audience representing the respondent.
Okay.
Is there anybody here?
Yes.
For this case?
Okay. Perfect.
Sorry.
Is there a suggestion for a fine amount?
I believe it was $50 a day thereafter.
Yes, $50 per day thereafter.
30 days?
30 days.
Your name and address, please, sir.
Michael Ichko, 45 Northwest 8th Avenue. I represent, number one, I wasn't present when these trees were cut. These were done by a landscaper. I have a paid receipt dated when he did it, so we'll make that clear. Exhibit number 5 right there, that tree was growing up against the house and causing damage to the house. That's why it was trimmed back. The one that's next to the driveway caused major damage to my truck going in and out. The last property owner abandoned the house before I got it, and no maintenance was ever taken care of those trees. So my intention, as well as David says we've never spoke, but yet he's going to answer my intention of what I was trying to do with those trees is clearly false. I don't know how I came to that conclusion if we never spoke, was that I authorized my landscaper with a sum of $300 to trim it back. It's unfortunate that he overcut the trees, but I believe if the intention, as Mr. Glover said, that we were trying to deface and destroy the trees, I think he probably would have started at the bottom and you would have saw him probably fall over, not spend $300 to basically ruin a set of trees. Wouldn't really make any sense. Number two, this started as a 4/16/16 warning notice. I don't know how this got escalated to a 4/16/19 later on, but it did. This is a vacant property, so I'm not there every day. Sometimes I'm there for days, sometimes I'm there for weeks, sometimes I'm there for months. I saw this blowing in the yard. By the time I saw this blowing in the yard, I already had certified mail sent to me informing me of the violation in a hearing in which the violation didn't even match the initial door notice. So it changed. It would be like you got a speeding ticket for going X amount over, and then by the time they mailed it to you, they said, no, sorry, it was reckless driving. So I don't know how it got escalated without, and to my knowledge, Mr. Glover didn't even come to the property. So we'll just clarify that. Number two, if we are gonna take it as a 4/16/19, according to that code, in lieu of replacement, the property owner may have the option of contracting with a certified arborist to provide medial pruning to the disfigured tree over a period of 3 years in an effort to repair the structural damage of the tree if the opinion of the arborist can be accomplished. A arborist report was submitted on July 22nd that clearly indicates the trees will grow back perfectly healthy. We're not removing the trees. Our intent was never to destroy the trees. I'm just trying to prevent damage from the roof, clearly, and damage from my truck in the driveway. I don't know if you have I would assume you don't have the report on file because it probably would have been presented, or has it not?
Can you provide it to Mrs. Warren, and then maybe we can introduce it into evidence?
This is the arborist report?
That's what he's said
Okay,
as it
so
is.
before we even get to the arborist report, because that's a remedy if hat racking has been found. So I just want to be clear, are they not, is it not in dispute that there was a violation of this section for hat racking?
I don't believe so. And my thing is the permit process, right? You still had to get I know you had them cut and they went crazy and cut it too much, but you didn't have a permit to get that cut. And that's the problem, I think. that
We need a
didn't
permit
get
to trim trees?
No, you don't need a permit.
But to trim them to
Not-
that extent.
I wasn't, like I said, I wasn't aware I wasn't.
Without a doubt, I get it, but I think.
Had I known.
Right, but I think you're probably responsible for what your people did, right?
I mean, at the end of the day, I'm the homeowner,
Right,
yes. I'm
exactly.
fully responsible for
So, I
anything
mean,
that happens on the property.
I mean, there's a lot of things going on here.
Of course.
I just think we need to approve for a permit, and then your arborist comes in, or somebody comes in and says, let's get this fixed. Here's the 5 ways you can get it fixed, type of thing. But we have to apply for a permit, which is kind of all they're asking you to do. I don't think you can do anything going forward without a permit.
So all the exhibits you looked at of the trees showing right now, I've already had them professionally trimmed by. This is already ready for another trimming. I've already trimmed these trees, $1,400 on 129. So you could see the rate at the growing back. That obviously.
I saw that picture.
Yeah.
I was surprised at.
So they're ready for another trimming again.
But I believe the city still says you need a permit, so I believe we're out of compliance because we don't have we have to get a permit to go forward.
Right, and I think that's what I was.
If
That,
I'm not
that is
mistaken.
that is correct. That is what the city is saying, and that's why I asked the question about, well, are we here?
Right.
Is he disputing the violation, or are we trying to get to the next step, which is compliance? Because there is a route, and the city has identified that and has received that arborist report, as he stated. But there's a couple of other things in that section of the code. It's
Right.
not just submitting the arborist report. There's
Right.
another step.
The fact of the matter
So-
is, you didn't get a permit, and I think we were all surprised when we saw what your landscaper did, right? I mean, all of us kind of jumped back when we saw what that tree looked like from where it was. I'm sympathetic to where you're at,
Yeah.
but I also think you need to get a permit and work with the city to get it fixed, so we can do what
Well,
has to be done.
That's the arborist report. Is anybody here a certified arborist? Just raise your hand. Anybody?
Oh, sorry.
So, to answer your question, Mr. Chairman, may I address the witness?
You may, Steve.
Thank you for coming. Appreciate it.
Yes.
Sorry that was blowing around in your yard. I own a property with a lot of trees, and I can empathize. However, when I read what the city has here,
Yes.
and what David tried to explain from his managerial position, there are some technical aspects to it, and they're all covered in the tree permit. Let me ask you a question. How much does a tree permit cost?
$25 per tree.
$25.
That's true.
So it's a courtesy as
That
a
was-
resident to cooperate with it.
Permit. There is no permit for trimming.
There is no permit for trimming, but there is a permit for tree
The tree
removal.
permit,
But we're not
when it's
removing the
removed
tree.
beyond a certain limit, it requires a permit. And that's kind of what it's explaining in the vernacular we have in front of us. In other words, he was trying to explain in his professional testimony, you asked who's a professional, he is our city's professional. And he was explaining that for so much trunk, there's so much canopy would be the word.
Yes.
And I heard it in his testimony, and I know how you feel. Like
Yeah.
I said, I have trees.
Yeah.
And so I hear you. So, and this was a while ago, but the city's asking that you get a permit and you cooperate with them, and that everything moving forward, including the money you're spending, is right in line with what our code is. And I don't think it's unreasonable for us to ask you to pay $25 within the next 30 days to obtain a permit and cooperate with the city. So that's my end of my comment.
Okay.
Can I, Mr. Chairman, can I ask that we consult with our attorney about the specific circumstances? It does seem on the face of it unreasonable to ask that the property owner obtain a permit for something that he does not have any intention of doing, which is removing the tree. But that is the remedy that the city is asking for. So perhaps our attorney can advise us on whether or not that's an appropriate remedy and whether or not the
Well, it's not the
board
most.
should consider
yeah.
a different remedy.
It's not the most artfully written code section. I'll be honest. I don't know that the board has to address that. I think if the board believes that a violation for hat racking has occurred, you can make that finding, and then you can give a compliance date, and then the respondent and the city can attempt to get compliance. And if the respondent feels if he's complied, the city feels that he hasn't, then that would come back at the lien hearing if it was appropriate. But I don't know that you have to solve that today.
So can I make a suggestion?
So, I'm sorry.
Oh, sorry.
So just to clarify, your recommendation is that we could find that there was hat racking that occurred, which would be a violation of this code, and give a date for compliance without specifying what that compliance looks like, and then leave that in the hands of the city and the property owner to
I
determine
think,
compliance.
yeah, first, I want to be careful with language. I don't recommend decisions to you because that is your judgment.
Okay, thank you.
I think structurally, when this board makes a finding, it is generally always the same at this procedural location, which is you find whether or not the facts, as you understand them, constitute a violation of the code as you read it, and then you give a certain amount of time for compliance. In many cases, not just this particular case, but in many cases, compliance can be many different things. And so I don't know that this board necessarily, I mean, even in this code section, it gives various ways that you can comply. I don't know that you have to mandate any particular one. You just have to give a reasonable amount of time to comply.
And as a suggestion, I would say if you want more of a concise language for compliance, the code references mitigation in circumstances such as the tree pruning. So if you want to say to properly mitigate in accordance with the code, that would encompass everything, and there could be several different types of permits or routes that they would go. But again, that's something that they would have to let the city know how they want to proceed, and the city would agree to it, and they will have to present certain things such as this arborist report, et cetera, to come to that conclusion of compliance.
If I may, it is blatantly clear, according to 41619, it gives you two options for hat rack tree. Replace it with two more, or provide an arborist report basically stating a path of healthy recovery. I spent $450 for a certified arborist to come out, evaluate these trees, give a detailed 18-page report to resolve the 41619, which, like I said, is extremely clear. It's
Excuse me, Mr. Chairman.
Yes, sir.
Is what he's presenting been admitted to evidence to us and provided to the
The
board?
arborist report has not.
Thank you.
But
That's not, and I was just trying to see if it was even
Please-
relevant
please
to
provide.
this
Oh, we don't
case,
understand
because
it.
that's not,
Listen, this is.
if it's even relevant
ridiculous.
to this particular case, we're here for hat racking, that's more of a.
we're here for a
Sir,
41619
I'm talking.
violation. I
We're here,
apologize.
sir, please let me finish. We're here for a hat raking case under 4619, right? And the arborist report will come in as a compliance method, not to prove or disprove whether hat raking occurred. So that's why I asked that question prior to its submission. But it's up to the board to determine what evidence they want to admit or not admit.
I mean, I understand the confusion, just for the board's help in deliberation. The question before you today is whether a violation of the code occurred and to give a reasonable amount of time to correct. The question of whether it's been corrected or not seems to be, judging by the way the city and the respondent are going back and forth, seems to be in some dispute. And that ultimately has to be resolved by this board, but it doesn't get resolved today.
Gotcha.
I would also like to offer the comment that I think, unfortunately, the owner is somewhat at the ability to hire someone, that the so-called licensed and authorized and qualified, whatever you want to use, per company that did the tree trimming, which was asked for by the owner, obviously did not understand what the city law says is allowed. And it's not the part, to a certain extent, I don't think we can fully blame the owner if he's not, if it's a partially owned property, he's there only part-time, and he relies on the so-called expertise of a so-called qualified contractor to do some work that turns out to be wrong. And the other thing is, and I think we need to somehow bring in the arborist report, because to me it's a key item, is it is mentioned to a certain extent in the LDR section that remediation by proper trimming, and as he said, he's had some professional trimming done on the basis of an arborist recommendation, and additional trimming is yet to be done. To me, that's a major remediation step that we can't ignore.
So let me clarify the arborist report and why it's even relevant to this section. If you look at 4.6, and I didn't think we'd be getting this far into the weeds, no pun intended. Section 4.619F1B, in lieu of replacement, the property owner may have the option of contracting with a certified arborist to provide remedial pruner to the disfigured tree over a period of 3 years in an effort to repair the structural damage to the tree. If the opinion of the arborist, this can be accomplished. A report, which is what we're referring to, from a certified arborist and a copy of the contract for remedial pruning must be submitted to the city, keyword, for consideration of this option. This is not a board determination. This is not an arborist determination. This isn't a property owner determination. This is a city determination. So that's why before we even got into what this report says, what does it mean, what's the remediation, how was it hat-racked, I just don't think that that's even relevant to this code enforcement
I have a question.
violation.
For our new board members and because of our previous discussions, what happens if we do find he did violate the code? If he does it again, then there are certain ramifications. Am I correct?
Yes, it could be treated as a repeat offender.
This is
Right. So by acknowledging it did happen, it kind of prevents it from happening again. Thank you.
Mr. Chairman, I have two questions.
Go ahead, Jim.
One for Ms. Warren. So you're saying that the arborist report is not something to be submitted after the fact. It had to be done prior to the tree hacking or anything that
So
happened to.
the hat racking comes into play after it's done, right? Like now we know that it's done. There's a section for this. So this is a remedial type situation. So once it happens, then we could cite for a code, and there's different routes to compliance or different routes to mitigate that the homeowner can take. But that's just one of the routes. And I think this homeowner is saying it sounds like they want to go that route, but it's not just submit the report, we're done. The city has to accept it, right? And I think that's more of a compliance issue and not an issue for this code board to determine. So that's the point I was trying to make.
Thank you. I also have at this stage, right? I have another question. So, as stated before, this is a 16-month. It's been ongoing for some time. Have you been in ownership of the property since the very first violation?
Yes, this has been going back and forth between my attorney, the city attorney, Lee Gowan, and unfortunately, we've had many permits because we were told to replace the trees. I have records of permit applications to replace them because that was recommended by the city. Permits went unanswered. They kept saying my tree guy who was installing was not licensed from the city. He's came down here 3 times on record, provided license, so it really stalled out. The only reason the violation got closed because of a deed change, end of the year, about 24. The only reason it basically got closed because of a deed change, and then Mr. Glover decided to reopen the case. So that's basically where we are today, but this has been going back and forth for quite some time to try to find a resolution. We've been actively working on this. We haven't had a lot of cooperation. My attorney hasn't had a lot of cooperation either. And obviously once it was closed from a deed change, obviously there's nothing to pursue. Once it was open, we immediately responded with the certified arborist report stating that the trees will in fact grow back perfectly healthy within 3 years.
So yeah, I've just been sitting here and hearing everything. So just try to give you guys a brief, summary of everything that's been going on. This happened over a year ago in March. The owner was cited for hack racking. At that time, he wanted to remove the trees. I have the documentations here from where he submitted to remove all 4 trees on the property. I denied it. I did not want him to remove the trees. At that time, I was telling him to try to preserve the trees and do this, and that was the dispute there. Since then, there was a deed change to where code enforcement closed the case. No compliance was done, so that's why the case was open again. At this time now, we have received a arborist report saying now he wants to keep the trees because at first I was asking for so much mitigation. So it's just have been going.
Can you explain mitigation? Because I'm not sure if everyone understands what that would be.
Right.
Would
So mitigation would be adding more trees than just having reluctantly the 2 that he hack racked. This has went, as far as up to our city attorney. It has went to Warren. It has went to the case to where it went to magistrate with his representation at first. They made an agreement at that time with the city that they will come into compliance. They will listen to me. They will do whatever the code section said to come into compliance. And sooner or later after that, there was a deed change.
So basically, we just wanted them to come in to compliance with the mitigation to preserve the canopy, correct? Okay. So as you can tell, I mean, this is a lot of information that I don't necessarily know is relevant to the case. So let me try to reel it back in a little bit. Just simply put, we're here for the hat racking. We're just asking that the board find them in violation for the hat racking and find that they have 30 days to apply for the proper mitigation with the city.
Ms. Warren, I got a question.
Sure.
But we want to help the homeowner come into compliance, and I think what we're struggling with is we don't know what that is, because if you're asking him to put a permit for removal.
What? Nope. Let's stop there. We're not asking him to submit a permit for approval. We're asking him to have proper mitigation, which could be if he wanted to remove the tree, he can do a tree permit remove. I mean, I'm not giving any advice. I just want to start there. Okay. We're not asking or telling him which route of compliance to go. We're saying submit something to the city for how you want to handle, how you hat racked your tree on your property. And compliance could mean different things. Compliance could mean apply for a tree removal permit, which is what they did, where they would have to, remove the trees. But based on our code, not Mr. Glover, right, it does say that if something is removed because it was hat racked, there has to be proper mitigation to the DH level. That's not my expertise. I mean, Mr. Glover explained it, right? It would have to have certain tree mitigation, which means you have to replace these trees. Our goal is to replace our preserve and replace our canopy in our city. Or if they wanted to keep the trees and properly prune them, they can go the arborist report route. So we're just saying within 30 days, submit the proper route that you want to go through to fix the hat racking violation.
I'm going to make a statement and a motion. First of all, I don't feel that the property owner did this on purpose. He hired someone who wasn't experienced enough and has caused grief and aggravation in his life. And I think the easiest thing would have been, hey, let me go pull permits, rip the trees out, plant some new trees, I'm done. He took the time and effort to go the route. Okay, people do deed switches all the time, could be estate planning, whatever it may be. And it would have been cheaper for him just to go yank the trees out.
Which is what he applied for and which is what we made the recommendation for,
So
but he elected not to.
I'm sympathetic for the homeowner, and I think that now he has done his due diligence. The trees look terrible, but they actually grew back and they look fine. And you plan on keeping the trees, correct?
Yes.
So the easiest thing in the world then would just to be able to file for a permit if he's going to keep the trees and submit his arborist plan and hire a more reputable tree trimmer, because I went through this on my HOA with my own gardener. Supposed to trim them, hack them, I had to buy new trees, the HOA fined me, the whole spiel. I didn't have to go in front of code because it was an HOA. So I'd like to make a motion, Mr. Chairman, with respect to case number 25-000038. I move for a finding of fact and conclusion of law that there's good notice and violation, sorry guys, to the homeowner that exists on this property. My suggestion would be the offending party shall correct all the violations within 30 days. I don't think there should be any fines assessed on this, and he's to be bring it into compliance within those 30 days. He should immediately notify code enforcement and our landscaping department when the property is brought into compliance, and if a violation is not brought into compliance, then the code enforcement officer shall report back to the board. In the event of non-compliance, a lien can be assessed in a daily amount upon the property. I mean, the trees grew back.
Well, can we just comment on whether the trees grew back to the proper canopy or how it was supposed to look before they were cut?
No,
Before we get there,
understand.
there has to, there's a motion on the floor, so we need to, a second.
I wanted to clarify, may I? I
of
appreciate
course.
your part.
He didn't get up on a ladder and cut the tree,
So,
and we're punishing him.
no, my comment earlier was, we want to make sure, I trust him as our neighbor, but if we find that it was coat racked in fact, then if it ever happens again.
But he didn't do it.
Well,
And if it
it
happens
was his
again,
problem.
then
Motion
it's-
is to find that he did do it, that he did hat rack it.
Okay,
So
that's what I
he
wanted to
would
get
be
at.
a-
Thank you, Todd.
It would be a violation.
Thank you.
Yeah.
Yes.
It's fair.
Mr. Chairman,
It's a violation.
we have the motion on the floor, but can I ask a question of the homeowner?
Certainly.
Are you prepared to bring to the, are you able within 30 days to bring to the city both the arborist report and a contract showing that you have arborists that will
Yes.
care for that?
The arborist report was submitted before it was due on July 22nd. I have a timestamp file. There's a full original colored original
But the other
print.
piece of that is the contract to continue to care for the trees through the 3-year period. Are you prepared to follow through with that within the 30
Yes,
days? or-
that is part of the mitigation process going forward, which should be trimmed accordingly between 9 and 12 months for the next 3 years. I'm very well aware of what needs to be done.
Right, but I want to be clear that it has to be a contract submitted with a licensed arborist to do the work. This report is
So, I'm sorry, I'm going to interrupt you here. So as long as he submits that contract with a certified arborist to do the work through the remaining 3-year period, that would be compliance
No.
when he submits that report?
No,
or no?
it's not compliant. That is
Okay,
not
so
compliance
what-
because here's the thing: the city still has to take into consideration all of the submittals and approve the submittals. Right? It's not just like, and you know, I said this earlier. That's why I didn't want to even get into this long conversation, because it's not like, hey, you submit the report, you submit the contract, we're done, we're closed. The city has to accept it. First of all, the city has to even determine whether the pruning is even appropriate, and that's kind of where, you know, I started saying earlier. It's not like you can just look at this tree, and I understand that we're
I'm
all
going to interrupt you as well. I understand all of that. My
Right.
question is, can he accomplish this part within 30 days? The city then has time to take action, et cetera. Can he get that into you within 30 days? If we give him 30 days under this, is that going to be sufficient time for him to meet that?
Yeah, that sounds like 30 days is appropriate, but I would also object to to the no fine portion of it that was part of the motion. Just for the record.
I understand that.
And then also for the record too, also on this report, I just want to be clear that
All right, am I correct? We have a second.
Yeah,
Jeremy, have a
yeah,
second?
you do have a second. Just for clarity, because I think that it's become convoluted. This board need not make a determination about compliance today. You give a certain amount of time for compliance.
Right. I'm just
Right.
trying to make sure that he has
If,
time for
if
that.
there, I mean, functionally, for any code enforcement case, if there is a dispute about compliance, the city brings the case back.
Right.
And then you make a determination that they either are or they aren't, and then you assess the fine from the original order.
Gotcha.
Though in this case, I think the suggestion here was no fine, which structurally is a little different.
Yeah, I would like to say, the exact wording is different, but I think we should put a decision on hold until the city looks at the arborist report and the recommendation that the arborist has made and accepts what's there to any extent. And if they want to add additional mediation requirements that they feel they are entitled to ask for, such as, you know, planting another tree here or there, that we wait until that information exists so that we can consider the whole project soup to nuts and get a valid
Mr. Cohen,
solution.
that would be appropriate
help
if,
people.
in your determination, you do not believe there are sufficient facts for you to determine whether a violation of the code has occurred. And
yeah.
then that might make some sense, but I guess the question is, the provision that the city has brought before you is whether or not a hat racking has occurred. And so you have to make a decision.
Yes, but I think remediation needs to
But
be
that's not up to
considered.
us.
No, it is because it's in the LDR section that mentions it. And I don't think that we can ignore that option that's available to the owner to do remediation in that way rather than, and why make them pay $25 for a tree removal permit that tree was never removed? That's almost.
I don't think the
Mr.
city
Chairman.
said that a permit is required.
Yeah,
They
it's not
said that
required.
mitigation is
It's not
required.
My
Can-
motion,
can
was-
I-
Chairman?
can I-
my
can I
motion was
add-
no fine.
Yes.
This is
Can I-
about a tree that was cut and it's regrown.
Can I propose an amendment to the motion that we fine 1 penny per day if?
Come on. Let's move this.
Let's, go ahead, Jim.
Yeah, so my understanding of what the city is recommending is that the violation has occurred and that we make a determination onto that.
Yes.
And that we ask for a mitigating permit from the homeowner. That will answer all these questions about what the arborist is saying, what is happening to the tree, how the homeowner is to move from there. So this board's position is to determine that from the inception there was a problem, and how do we fix that problem from inception?
Yes.
Which would be finding the violation as to the motion that's been
Violation
finding
happens.
it
We give them 30 days to fix
to
it.
fix it, which would be the mitigation permit.
Correct. And I just want to put this on the record again. I would highly object to no fine, 1 penny whatsoever. And just remind everyone, the property owner is responsible for what happens on their property,
Understood,
right?
but in a situation like this, it's like a bad haircut. You gotta
Well,
let your hair grow back.
I mean, I would dispute whether, modifying the tree canopy in the city is a bad haircut, right?
And I think that's very disingenuous to say that, because in fact, with you allowing a tree to grow back like this way, you're actually endangering the homeowner in a resistance in a windstorm, because that's exactly what his arborist report is saying. So when you do all these lateral cuts and cutting the canopy, it's like cutting your arm off. You'll grow a stump back. We're not in dispute that this tree would die or would it grow back. It's how structurally sound it would be. So when you have this tree like this with all these codominant branches now, you have, say, your arm, right? So now where it used to be strong and have one lateral point coming out, you have all these sprouts coming out, which you're putting weight on different spots that never used to be there. So that's why he's getting this arborist report to tell him how to cut that to make new lateral arms.
And if it's not corrected, isn't this something that could be a danger in a hurricane season?
Correct.
Can I make a statement?
That's exactly what his report is saying. So this report is not going against anything what the city is saying. He's disputing, which we've been going back and forth, was because I've been asking for this. In the beginning, he wanted to remove all the trees. So I said, if you remove all the trees, now all this mitigation is going to come in, because technically right now this property is not in compliance. He only has 2 trees on the property, which are hack rack, and per his approved landscape plan, he's supposed to have 4. So when this all came in and everything, I have told him for months, hey, listen, if you want to do this, get an arborist and rectify the trees, put in 2 trees, keep these 2 trees, you'll have 4 trees on your property per your landscape plan, and the city will accept that.
Thank you, Mr. Glover. But that is the end of the city's position.
Can I make another statement? Sure. What Mr. Glover says false. He says I'm out of compliance because I only have 2 trees. I have a survey from 2025 showing that there are 4 trees on my property. I'd be happy to submit this as an exhibit if you'd like.
I think we're once again diving into the weeds.
Okay.
That's not an issue.
Yes.
Okay.
Can we call a question? Is that?
Well,
You can, well, it's the chair.
Go ahead, Tom.
Yeah.
Mr. Chair, I'd like to call a question. So we have a motion that's basically means that I'm saying I'd like to ask that we vote on that. And when I call a question, we have to vote that we're going to move forward and vote on whether or not we vote.
I think we should vote on the motion that we have.
All right, fine. If you're ready to vote, I'm ready to vote.
All right.
All in favor of the motion?
Aye.
Say aye.
Aye.
All opposed? Motion passes.
So I just want to be clear on what the motion says. You guys are finding them in violation.
Yes.
No fine, so if they don't comply, then nothing happens. That's pretty much what it says.
No, he has to come back in 30 days.
Has to come
The-
back. He has
the
to
code
comply in
enforcement has to come
30
back in 30
days.
days, and
Just
then we have to
comply and come
reassess.
back in front of us.
I'd like to answer that again, too. By finding that he was guilty of the hat rack, we are acknowledging what the code enforcement officer recognized and presented was accurate. It was a violation of the
Right.
city code. So, thank you.
Thank you.
Thank you.
what, just to be clear, what is my path to resolution? What,
Within 30 days, you talk to the city and come to a resolution that they
It's not up
accept
to us
as
to tell you.
path to
We're not
compliance.
allowed to-
so there's no path?
Get mitigation. Get mitigation.
This board should not be advising about compliance.
Right. Thank you, Mr. Glover. Thank you, sir.
Give me a call.
Okay, case number 7, code 25000039. We're asking for a motion to postpone this case for 30 days.
Motion to postpone this, hold on a second, I'm so sorry. I can't hear, there's some, if you can call order in the gallery, please.
Everybody, please, order.
Now, Mr. Chairman, I'd like to make a motion that
Thanks.
we postpone to the next code date, case number 25-000039.
I'll second that motion.
All in favor?
Aye.
Case is postponed to the next meeting.
Okay, we're moving to old business, case 8, 244161.
Did you put on the record that this case is closed, the 26th, the 25000040? It's on my agenda.
Not on mine.
Is it on the board's agenda?
It was on the changes to agenda.
Yes.
It was on the changes, okay, thank you. And speaking, before we go there, speaking of the changes to agenda, there were other cases that we recommend postponement for. I don't believe we got a motion for those other two cases.
It's at 25000025, 3633, and 39.
Yes.
Those are all when we.
Yeah, there should be a motion.
There was a motion made for that.
No, there was a motion made for 3.3 and 3.9. I don't believe there was a motion made for the other two.
What are the numbers?
25 and 36.
Mr. Chairman,
No, they were.
That's Jimmy.
I'd like
Yes.
to make a motion that we postpone cases 0025 and 0036 until the next code enforcement.
Second.
All in favor?
Aye.
All opposed? They're postponed to the next day.
Case number 244161. This is for a release of lien and accrued fine, and the case is currently in compliance. It will be presented by Code Administrator Enrique Fernandez.
Good afternoon, Board. My name is Enrique Fernandez. I'm the Code Enforcement Administrator for the City of Delray Beach. I'm here regarding case number 244161 at 1098 Hibiscus Lane. I am here to request the records do the fine and the lien in the property be removed. And the reason is because we do have a new system that is called EPL, Enterprise Permitting and Licenses. And when the records were transferred from the old system to these systems, we found some discrepancies with some of the cases. This is one of them. So with this case, when it was transferred, there was no information in regarding the general permit. The permit that was for this specific violation was for a fence and tree removal that was in the actual permit, but it was not transferred properly. So the property owner had submitted for the permit on time, and we are requesting for that to be removed, a lien in the amount of to release the amount in the amount of $27,000 to be removed, and no fines to be continued on this particular case.
I'll hear a motion.
I'd like to make a motion.
I have a question. So there was some type of computer glitch from one software to another?
Correct.
That was the city's fault?
Right, and
It's
it's
it's not a city's fault. It's a new
Understood,
system.
understood.
It's a new system with a
Understood.
transferred information.
Understood.
We have some cases that the cases were not, the information, the data was not transferred
Understood.
properly.
It was a purge. Was there ever a violation on the property whatsoever?
There was once a violation, okay, the violator corrected the violation on time.
Okay, cool. All right, thank you. Thank you so much.
So I would like to make a motion to reduce the penalty. In respect to case number 24-4161. And I move that a finding of fact and a conclusion of the law that the violation is no longer exists on the property, and that the motion to reduce the lien amount from $27,100 be reduced to nothing, to zero, and that the respondent does not have to pay the reduced amount, and that the lien will revert back to the original amount.
Or the lien will be removed.
Will be removed, yes.
Thank you.
Second.
All in favor?
Aye.
All opposed? Motion passes.
Thank you.
Mr. Chair, if I might.
Please.
So hypothetically, sometimes there are cases for whatever reason that you don't necessarily want to define a fine amount at the first hearing in which you are finding a violation. That it's not common, but it can occur. In those cases, probably best practices are to reserve the assessment of fine, which is to say the board will assess the fine at a later date, which gives you the most flexibility. Because otherwise you are otherwise confining yourself to the choices that you make at the time. Does that make sense? Best practice of all practices is actually just to put out a number. Because remember, you do always get another bite at the number. Which is to say, hypothetically, let's say you have a case where you want to encourage compliance. And so you might actually put out, as sometimes occurs, a pretty substantial number because you want to impress upon the respondent the need to comply. And let's say the person does come into compliance, but comes into compliance maybe 3 days late for very legitimate reasons. There's no reason, you don't have to assess the fine in the way that you initially put it. You can, amend your fine and make it suit the circumstances, because circumstances change, right? But you always want to give yourself some degree of flexibility so that you can tailor the decision to the needs of the property owner, the city, to encourage compliance. Does that make sense?
Mr. Wagner, in that same sense, can we not amend the no fine to assess the fine if we find no compliance after
The
fact?
problem with, hypothetically, and not talking about any particular case, the problem with changing a no fine is that you've already structured it in a way that might present issues.
Fair enough. Thank you.
I'll hear a motion to adjourn the meeting.
Second.
I have a personal comment to offer. I will not be at the next meeting, September, must be the 11th. I will be in Colorado attending my granddaughter's wedding.
Congratulations.
Thank you.
Meeting adjourned.
Thank you, Mr. Chairman. You have long background?
Not yet.
Last try.
Not yet.
Some of them are crazy.
What I want to be.
The sunglasses.
When I go get on my ice. Ralph, okay, Ralph. And what I'm going to.
You leave them. Yep, yep.
Get the handshake, Jimmy.
If you wanted to take, like if you wanted to, you could take those if you want to look at it or anything like that, sure. Yeah, yeah.
So I was trying to tell you.